the record, Delegate Michelle Guyton, District 42B in Baltimore County, and welcome to housing. You guys got it from us this year.
And you took energy.
Don't ask me which I prefer. So we are, I'm here to ask for your consideration of House Bill 543, which contributes a solution for many of our state's most pressing problems resulting from a severe shortage of child care spots. And I know that I don't have to convince you all that this is a problem. It's one of the priorities of our Legislative Women's Caucus. It's one of the priorities of our comptroller to improve this system for women. Most of the 25% of our licensed child care spots that we have actually lost since the COVID epidemic have been family child care programs. And those are the ones which are home-based programs run, then have more flexible hours than others. They can serve folks at night. They can serve families who may have different working hours. And they also tend to be particularly an important economic opportunity for women, and particularly women of color. So sorry, I lost my place. The lack of licensed child care right now is an epidemic and a problem in our state, and it has forced a lot of families to make do with unlicensed and sometimes dangerous child care situations, and certainly not legal child care situations. And that's one of the things that this bill is trying to prevent. So one of the primary barriers to starting a licensed family child care program is that landlords regularly prohibit it in rental properties. As amended, and this is from last year's bill, House Bill 543 prohibits landlords from banning the operation of small licensed family child care homes, and listen to this part, only in single family rentals. These homes must be fully regulated, they must be fully licensed, and they have to already be go through all of the process already in place by the Maryland State Department of Education Office of Child Care. They have to abide by all the square footage, liability, responsibilities, insurance requirements that are already in place. In addition, after working with realtors on this bill last year for quite a long time, we gave them several amendments. One of them was that we made this only single family homes. The second was that landlords may collect an extra month of deposit. They have to receive significant notice, and they are allowed to conduct their own inspections when these programs are going to be run. And we have specific liability insurance requirements that protect both the owner of the property and the renter. So just so you know, this bill did pass the House last year. It got stuck in the Senate. Even though you do have an unfavorable from the realtors in your written comment today, I will say that last year, after we made all of these changes on their behalf in consultation with them, they did change their testimony to no opinion. This bill is in that same posture now that I present to you. And then the final thing I want to point out to you is that the fiscal note on this bill is what we all want to see this year. There's no significant negative fiscal note to the state or to the counties, but what it does say is that there is a potentially meaningful small business effect in a positive direction. So for all of those reasons, I hope that you will look at this bill, not as just a housing bill, but as an economic bill to help families in Maryland and our economy. Thank you very much.
Good afternoon, Madam Chair, members of the committee. Ellie Colmers on behalf of SEIU Local 500. We represent over 20,000 public service and nonprofit workers in Maryland. Our members include working parents, caregivers, and community-based workers whose ability to remain in the workforce depends on access to stable, affordable childcare. And we thank the delegate for bringing this very important legislation back again this year. On a personal note, my son attended family childcare in a rental home in Baltimore City, and I can't explain to you how wonderful it was. She was his second mother, Miss Shantae. I love her. So this brings clarity and balance to the issue of licensed childcare providers who often face unreasonable lease restrictions that would prevent them from operating in residential rental properties, while also recognizing the legitimate interests of landlords. It allows for reasonable notice requirements, liability insurance provisions, and appropriate security deposit adjustments so that landlords are not unfairly exposed to risk. In doing so, the legislation creates predictability for both tenants and property owners while removing arbitrary obstacles that limit childcare. Access to childcare is fundamentally a workforce issue, as the delegate said. When families cannot find reliable care, workers are forced to reduce hours, leave jobs, or delay career advancement. By supporting family child care providers, many of whom operate in rental housing, Maryland strengthens its workforce participation, particularly for women and low-income families. At the same time, this bill promotes economic fairness by ensuring that small home-based providers are not excluded from the rental market simply because they serve children. HB 543 is a practical step towards expanding childcare capacity, stabilizing small business. Thank you for your consideration. We request a favorable report.
Thank you. We'll start with Delegate Ahrens, then Pippi, and then Adams.
Sure.
Thank you, Madam Chair. On the insurance stuff a little bit. First of all, you said something about only in single-family homes.
Yes.
Is there another law against that? Why that? Why'd you preclude it?
There is not a law against that right now. These decisions are made on a case-by-case basis, and they can be rather arbitrary. The reason I point that out is that the bill originally last year, when it got a lot of negative attention, was a bill for multifamily homes, apartment complexes, and that we worked with the realtors to limit this bill to only those single-family homes.
Okay, the reason I ask that is a lot of these multifamily units are rented. And a lot of these people that rent actually need the second income. This bill precludes them from making money, is that correct? Or does it preclude, or can the landlord make that decision?
The landlord can still allow that to happen, but under this bill, landlords of single-family homes must allow that to happen.
Must let them happen. And do me a favor, you mentioned the insurances and stuff. What were the options on insurances?
So I don't have the exact insurance information in front of me right now, but I do believe, if I recall, that the realtors wanted to have an extra $1 million liability insurance, and that they wanted to make sure that both the family child care home itself was covered, and also that they were covered by that insurance as the owner of the property. And those were the changes that we made last year, as suggested by the realtors.
Okay, let's say I own the property and you came in with, you want to do that. My insurance rate could go up for me.
No, this is insurance that the owner of the family child care would have to provide.
So that's an additional, you pay that as the.
Correct.
That rent. And then you said something about a month's rent for what?
They can collect an extra month deposits, just to make the landlords feel more comfortable with this bill.
I said bottom line is the landlord is held harmless no matter what happens in that
Correct.
house. Okay. Thank you, Madam Chair.
Thank you, Madam Chair. Delegate, good to see you. Good to see you both. Couple questions just shows I think about this. So if you have, the bill would kick in hypothetically October 1, 2026. Let's say somebody in the last month signed a 1-year lease for a single family home. So would this bill allow an existing renter in a single family home, should this take effect, to then start a daycare business in the house and the landlord couldn't do anything about it?
If they followed all the provisions of both this piece of legislation and the requirements of MSDE, then yes.
Okay. The second part, and you never want these things to happen, but I'm just trying to think, sometimes there's disputes, right? So this committee's getting acclimated with the landlord-tenant ongoing debate, I guess. But sometimes tenants don't pay, right? Sometimes justifiably, sometimes non-justifiably, but the process of getting a tenant out is very long. Matter of fact, in some jurisdictions in Maryland, you can't even evict somebody unless it's above 38 degrees. Think about that. So it's been very cold, right? So how does it work when someone is operating this business in a house and they're not paying the landlord at all? Is that a consideration of this bill? Should there be something there about that issue?
Yeah, no, it's not a consideration of this bill.
Okay, so we could have a scenario, hypothetically, where somebody signs a 1-year lease this month, they get in, they've not paid their landlord any money whatsoever, they've started a daycare business, and it's like, I mean, I guess that's a good business, right? You don't have any rent, you got, okay. Thank you.
Can I respond, actually? I would say that actually the impetus to this legislation is the reverse of situation of what you're saying. So we have well-established family childcare providers in rental homes. The home is sold by the owner, as is their purview, their right. But then the new landlord will come in to this family childcare that's been around for however many years and say, no, you can't do this anymore. And then not only is the business gone, that small business owner no longer has that business, the ability to have that business, but then also all of the families of those children who are there are without care. So I understand where you're coming from, but the impetus to this was actually the opposite.
And I just want to say, so just for the record, so I have two young kids, and we rely on daycare quite a bit. It's a big thing. You can't go on date night without daycare. I mean, there's a whole bunch of things involved. So I certainly want to make it easier for people that want to open a daycare business. I just want to balance that with a landlord who's like, I didn't approve this, and now you're running a business out of my house that, you know that already.
Thank you. I really appreciate the fact that you are very sensitive to the problem as a father of young children. And I hope that you will support it because of those reasons, but also because we worked with the landlords very hard to make sure that their concerns were met in this bill.
Okay. All right. Thank you.
Chair. So the first question I have, and thank you for the bill. I'm going to have problems with the bill, but it's as Delegate Pippi says, the nature of the problem is real. And as a father of 3 who are now adults, the financial contribution that me and my wife had to make this work was difficult at best. A tenant shall notify a landlord in writing at least 60 days prior to operating a family child care home on the leased premises. What if they don't give me 60-day notice? What's the relief under that circumstance?
Then you don't have to approve that they are not allowed to do it under this legislation. We don't want any landlords to be surprised that all of a sudden there are small children in their rental property. So this is protecting them so they can prepare for that.
So one of the first concerns I would have in a single family on the Eastern Shore, properties on septic systems, 3-bedroom house, we'll call it 3-bedroom. So occupancy could be like 6, 2 children per bedroom plus the family unit in the 3rd bedroom. And so, literally this would, for a daycare setting of maybe say 10 kids that come in every day of the week, you're going to threaten or risk the usability of that house virtue of the septic system. So we've had those conversations literally yesterday. And are you concerned that you're making a commercial enterprise out of a single-family residential property and how that may affect that sort of scenario?
I'm sorry, your question is?
Septic systems are only built for or are designed for certain occupancy, single-family uses. Putting a child care system in is a commercial enterprise for which the system doesn't allow for it. It'll fail, is the point.
Are you asking me whether I agree with that statement?
I'm saying the bill.
I'm still waiting for the question. I'm sorry.
Landlords have many good reasons why to not support a bill like this. I'm sharing probably one of the top ones that I would have.
Okay, thank you. Thank you for sharing your thoughts.
There's no way, so it is a question. You're trying to pass a bill for which landlords will disagree with, and one of those is that you're putting a commercial enterprise in a residential setting. It's not just about kids out in the backyard running around and getting hurt. It's about, are the systems in place to support a commercial enterprise?
MSDA has very strict inspection requirements, and they would not approve a place for a family child care. And I also want to point out, I think you mentioned 10 children. This one's limited to small family child care centers, so they would be 8 or less.
8, okay.
So they would not be, if that space did not fit the requirements, that are already in place with MSDE as far as square footage, number of bathrooms, inside and outside space, fencing, there are a lot of requirements, then it would not be approved. So I think those things would be addressed under that process.
Okay,
So,
my last question.
so I disagree with your statement.
Okay, fair enough. My last question is on lapse of coverage. So in our business, we have subcontractors, so it's not directly the same thing, but we require ongoing insurance being in place when you do business with us. It's not unusual for people to have their coverages lapse. And so, as Delegate Pippi said, we don't like to think about the worst-case scenario, but the worst-case scenario would be a death or severe injury to a person in the house, and all of a sudden you realize that the tenant who's running a commercial business doesn't have coverage. Now, I know how insurance works. They subrogate, they look for money wherever they can find it. If there's a lapse in coverage, they will come to me anyhow. So the question is, how does a landlord protect themselves against a likelihood, in my opinion, of having insurance coverages lapse that are aimed to help against these worst-case scenarios?
Yeah, thank you for that. I'm not an insurance agent or an expert in that field. I do know that the realtors last year put this into effect and felt that they would be held harmless by what is in this bill. And I don't know that process would be any different for this scenario than for, another scenario where you own a property and someone is hurt or someone is injured. I wouldn't think so. I think you have to have insurance in the state of Maryland.
It's not far removed from having car insurance. There is
Right.
uninsured motorist coverage for people that don't have insurance because they let it lapse. There would be no similar version of that in this setting. So I'll leave it there. Thank you.
Thank you.
We'll go with Delegate Wyville, Ampry, and then Chi.
Thank you, Madam Chair. I guess my questions were similar along the lines of Chris's, but, and you said you're not an insurance expert, but don't a lot of the landlord policies prohibit commercial activity on the property, and how have you addressed that?
I don't address that in the bill. I don't believe that is an across-the-board insurance issue because many landlords do allow childcare to operate out of their rental properties. This one is aimed at those who do not. So obviously many are also already doing that with the comfort that they're protected. So I'm sure that there is a way that we would be comfortable with.
I'm not so sure that's true. I think that some policies do prohibit commercial activities on the property, and you're in violation of those covenants, and then they could potentially drop your policy. But so how does the bill cover the landlord in a situation like that?
The owner of the child care, the person who's running the child
I'm
care
talking about
center
the person who owns the property.
is required to cover the landlord under their policy. That's how the landlord is covered.
Right, so going back to the
And that
lapse-
was suggested by the
Going back to the
realtors.
lapse in coverage then, are they required in the bill to provide coverage, notice of coverage and ongoing coverage to the landlord?
I'm not sure we specified that in the bill, but it would not be a bad amendment if you wanted to add it. I would consider that friendly.
All right, and then, I mean, I know there's a ton of regulation, because we live in Maryland on rental properties. So, all the health department issues, the lead-based paint regulations, zoning and all that, who is responsible for that? I know if you have a child under 6, there's certain lead-based paint regulations that are different if there's only adults live in the property. So is the landlord then required to have additional compliance measures taken to comply with the child care center now being in his house?
Well, I think as far as lead paint, we do have a lot of regulations regarding that, whether or not you have a child care center in your property. But I'll leave that aside because that doesn't really speak to this bill. The answer to, I believe the question you're asking is MSDE does. MSDE is the one who has a lot more restrictions on what the child care space needs to look like and feel like, and the requirements that are required to make that safe space, that space safe, and they would be the ones doing that inspection to make sure that it did. If that space were not safe for any of those reasons or any others that you mentioned, then it would not be the responsibility of the landlord to fix them unless under current housing law, they would already be necessary to fix them because they were breaking the law, but not because there's a childcare being run out of there. In fact, if it were determined that that space was not appropriate for a childcare, then MSD would not license that center. So it is not the landlord's responsibility unless he's already, not adhering to laws that we put in place for child safety.
Okay, all right, thank you.
Thank you, Madam Chair, and thank you for bringing this bill forward. We know that we have a housing shortage and we have a child care shortage. I have 2 young kids, so I know this is trying to tackle the child care piece, but one of my concerns is like how does this affect the housing piece that we need? So it's kind of a weird conundrum that we're here in Maryland, but we got to find some solutions. So I appreciate you all trying to find a solution. I have 4 questions, but I'm going to try and make this rapid fire so that we can get through this as quick as possible. Are there any other states that have this in effect?
Yes.
Chris would know, and she's
We do have
virtual.
2 other virtual favorable panel witnesses, and they're going to address those.
so let's
If you're
go
okay
She's the
waiting for that answer,
expert on
because I
Answer
don't,
that
off the
question.
top of my
Okay,
head,
I
I'm
want
not
to
sure.
stick to this. Number 2, are there any other businesses that we would require a landlord to accept to do business in a residential setting? Is there any other type of business we allow this for other than childcare?
I don't have the answer to that either.
Okay.
I can tell you that it does happen. We're just addressing the times when it doesn't.
Yeah.
So it is.
The other question is, will the landlord be responsible for updates to the home once the child care system is now started? Let's say you have child care, it's moving, it's going well. Next thing you know, I got 2 kids, they tear my house up, so I can only imagine what 8 would do. So let's imagine that the drywall gets busted up and something happens. Is the landlord going to be responsible for having to fix those items?
Absolutely not.
Okay, so I understand there's insurance, but there's a different, so the responsibility would be on the tenant to take care of all damages that happen to the property.
Yes.
Loss.
And if those things continue to happen, and if they did not keep that space safe, it's likely they would lose their license.
All right,
to run that childcare.
Last question. How does the bill address any type of HOA or local zoning laws that would say that in this neighborhood, we do not allow we don't allow commercial businesses in this neighborhood. We
Sure.
don't allow, so how would you address, how does this bill address that?
So the Housing Committee last year dealt with that, and we passed a bill that already addressed the HOA issue. So that's already off the table. They cannot pass those legislations.
So the HOAs can't pass it?
They cannot.
Okay, so but
That's prior year legislation.
okay, all right, thank you, I appreciate it.
Before I ask the next question, I just want to piggyback off Delegate Amprey's question. You mentioned, Delegate Guyton, that the unfavorables would cover the question about, is this in other states?
No, I'm sorry, the favorable. I don't have any unfavorables today.
Okay, I thought you
Yes.
said the unfavorable.
We
but-
have 2
so
favorable panelists that are on virtual.
That will answer that question?
Yeah.
We believe so.
Okay, thank you. Delegate Chi?
Thank you, Madam Chair, and good to see you, Vice Chair. I fully appreciate the spirit of this bill, and I think it's addressing a pressing issue. So I have a couple of questions. One is, do we exempt the owner-occupied single-family homes, or does it apply to everyone?
Yes, we do.
Okay, thank you. And I heard Ellie mention earlier, the impetus of the bill was because of the switchover when there's a sale of the property and the new owner decided to discontinue, right? And I can appreciate that scenario. So have you considered perhaps to limit the bill to just grandfathering in those existing ones instead of requiring all homeowners to have to grant the rights regardless of the situation?
I appreciate your thinking outside the box in that way. I have not. Actually, as you heard, this bill started out as a more expansive bill, and we whittled it down to a very small percentage of rentals from where we began. We have lost a whole lot, 25%, more than 25% now of our child care spots. And even if we were just to grandfather those in for future changes, we're affecting very few spots that way. We would affect some, but it would be very limited. And what we're trying to do with this legislation is actually increase spots and increase the economic viability of those families. And if I could just add to that briefly, based on one of Delegate Amprey's questions, he asked, how does this help with housing? it helps with housing because the families, often women of color, usually women of color, who are able to run those businesses out of their home can now pay their rent and not be evicted. Thank you.
Seeing no further question? Oh, no, Delegate Bandari.
Yeah, thank you, Madam Chair. Thank you, Vice Chair, for this wonderful bill. I'm reading your testimony. Given the 25% loss in licensed childcare slot since COVID, particularly among family childcare homes, can you explain how this bill both expands SAFE, MSD licensed childcare option for working families, and women entrepreneurs while still preserving landlord protections through a notice requirement, as you mentioned, additional deposit inspection right, and joining compliance and $1 million liability coverage. You want to comment on that?
Thank you so much for that very friendly question, or should I say hard-hitting question. Exactly what you have just said. Yeah, this really does open up economic opportunities for, and it's not just women, but families who want to have a viable economic opportunity in their homes, and for families and women in particular who need to be heavily protected in this legislation. So thank you for pointing that out. I appreciate their support.
Thank you.
Seeing no further questions, thank you, Delegate Guyton.
Thanks.
We will now move on to the virtuals. We have Christina Poosh.
Hey, I'm not sure if I'm started. Okay, can you hear me?
Yes.
Okay, great. Thank you. It's a great, robust conversation. Thank you, Chair, Vice Chair, and the members of the committee. And thank you for the opportunity to testify. My name is Chris Push. I'm here on behalf of the Maryland State Child Care Association, co-chair of the Office of Child Care Advisory Council, and strong support of House Bill 543. Maryland is in the middle of a child care shortage. As you heard, that is hurting families and our economy. We've lost more than 1,200 providers, businesses, and over 12,000 childcare slots in recent years. Parents are struggling to find care close to home, and employers feel the impact when workers must cut hours or leave the workforce. Family childcare homes are the fabric of communities and are one of the most effective ways to rebuild that supply. They serve infants and toddlers where shortages are most severe, offer non-traditional hours for nurses, first responders, and shift workers, and provide culturally responsive care in neighborhoods where no other options exist. But many of these providers, who are often women, immigrants, and small business owners, face barriers simply because they rent their homes. House Bill 543 removes those barriers with a balanced, reasonable approach. First, it prevents blanket prohibitions on licensed, lawful family childcare homes. Providers who meet every state requirement should not be denied the ability to operate solely because they're tenants. Second, the bill includes strong protections for landlords. Tenants must give 60 days notice, provide proof of registration, and carry liability insurance up to $1 million with the landlord named as the additional insured. And critically, landlords receive explicit immunity from civil liability for acts related to the child care operation. That directly addresses one of the most common concerns heard from property owners. Third, the bill creates clear expectations and accountability. If the insurance lapses, operations must stop. If a provider closes, the landlord must be notified. This ensures transparency and shared responsibility. And importantly, 543 does not override zoning, does not apply to owner-occupied homes, and does not interfere with age-restricted communities or condominium bylaws. It is targeted, balanced, and respectful of property rights. At its core, House Bill 543 strengthens Maryland's workforce and economy. Thank you.
Ms. Poosh, I'm sorry, you didn't have to rush and lose your breath. I appreciate your testimony. I thank you for your passion.
You're welcome.
Yeah. Seeing there are no questions for you, thank you for your testimony. We'll now move on to the next virtual, Ms. Ruby Daniels.
Hi, everyone. Can you hear me? So my name is
Yes.
Ruby Daniels, and I'm here representing nearly 4,000 providers in Maryland. Family childcare, we operate in our homes, and we care for infants and young children, often early mornings, evenings, and other non-traditional working hours. We are essential to Maryland's childcare system, yet one of the biggest barriers is nothing to do with quality and licensing, its housing. I regularly hear providers who rent their homes and are told that they cannot operate childcare, are denied leases, or are forced to close simply because a landlord says no. These are licensed providers meeting all state health and regulations and safety requirements, yet they are treated as a liability instead of a community asset. At the same time, family childcare programs are declining across Maryland, while the need from working families continue to grow. Parents call us every week looking for infant and toddler childcare. This bill can help remove unnecessary housing barriers and allow providers to open and expand, adding much needed childcare slots for families. House Bill 543 offers a reasonable, balanced solution. It protects providers from being unfairly restricted while still allowing landlords to require like business liability insurance. I do have one, 1 million, and extra months security, and also providing liability protection from the landlord. Like what I heard just now is that what if Johnny paints the walls or destroy the drywall? We can do home repairs, and that's part of our operating budget, and we can take that liability off the landlord's hand. If we want to strengthen Maryland's childcare system, we must protect the providers to make it possible. On behalf of Maryland and the 1,000 providers we represent, I urge a favorable report on House Bill 543. Thank you.
Thank you, Ms. Daniels. Our last virtual is Umera Anwar.
Good afternoon, everyone. Hi, my name is Umera Anwar. I am a family childcare educator for the past 10 years, and I'm also a mother of 6 myself. So this was a good opportunity to raise my children as well as run a business and provide for my family. I'm also a Maryland Excel Level 5 accredited, and I also serve Family Childcare Association of Montgomery County, where I serve as a regional director. We have been living in this current home for approximately 7 years and have successfully operated our family childcare business from this residence throughout that time frame with full enrollments. When we renewed our lease last year, our landlord informed us that he had planned to sell the house within the next 5 years, and at that time we expressed our intention to purchase the home when it became available for sale. Our landlord had generally been very cooperative and was very responsive, but this response was unexpected for us. He stated that he did not want to go through the additional process and subsequently revised his timeline, indicating that he now plans to sell the house within the next 2 years. During this time period, we were actively pursuing a forgivable loan, relying on the understanding that we would be able to purchase the home within the originally stated 5 years time frame. This plan was central to our long-term business strategy, including expanding our licensed childcare capacity to a large family childcare program. However, our ability to move forward with this expansion is entirely dependent on receiving written approval from the landlord, which has now become a limited factor in our future business plans. As a result of this change, we are now scrambling to either purchase the home within the next 2 years using the limited savings we currently have available for a down payment, or relocate to another rental property and rebuild our family childcare program from the beginning. Both options create significant financial and operational uncertainty for our family and for our business. I thank you for your time.
Thank you, Ms. Anwar. Seeing no questions, thank you all for your testimony this afternoon. This concludes the bill hearing on House Bill 543.